Okay, I think we've plateaued out. The ticker is not going up anymore. Like Netflix, I like to keep the total number of participants in my webinars commercially confidential, so you can all just assume that it's wildly popular. Today is the latest webinar in our King's Young Professional seminar series. I'm going to be talking about the tort of conspiracy. What is it? And where to look? Joseph Heller said, just because you're paranoid doesn't mean they aren't after you. The tort of conspiracy is often a bit like that. The tort has, well, there are different ways, as there always are, breaking these things down, but for the purposes of today, I've broken it down into 4 elements for tort. First is a combination between 2 or more persons. The second is an intention to injure the claimant. And I've deliberately worded that in a slightly vague manner. The third are acts carried out pursuant to the combination with the necessary intention. And the fourth is loss and damage caused to the claimant. Now, the idea is to keep this talk bite-sized, so we're not going to look at all of those elements, but we're going to look at the ones that I think are perhaps the most interesting. And that starts with the combination. Now, here we have a picture of probably the most famous conspiracy in English history, the Gunpowder Plot of 1605. And these gentlemen were very kind. They stood still long enough to enable somebody to take an etching of them conspiring and entering into their combination. If you are acting for the potential claimant in a conspiracy claim, you are unfortunately unlikely to have a drawing of your conspirators engaging in their conspiracy. So what do you do? The first thing to say about the combination is that the word combination is used rather than agreement, because it's not necessary to prove that the conspirators entered into an express agreement. To some extent, it's the question of the nod and the wink. And it is not uncommon that direct evidence of the combination will be unavailable to you, although it has to be said that people are increasingly, in my experience, careless with messages and emails. Now, that may be something that's going to fall off, but I think from a practical point of view, what we've perhaps seen in the last few years is that with the increasing availability of encrypted messaging applications in particular, people have thought that they can afford to say whatever they like. And as politicians are certainly learning, your WhatsApp is only as secure as the person on the other end of it, because obviously they can be screen grabbed, they can be copied. Just because they can't be intercepted and encrypted by third parties doesn't mean that they are in fact secure. So we have seen over the years an increase in the number of effectively incriminating messages that have been available in the law and disclosure. But I think now we're starting to see people getting more aware of that. And it may well be the case that we start to see a fall off in the number of cases where there is good direct evidence of people communicating in a nefarious way. Ultimately, it depends on the conspirators you're dealing with and how savvy they are. But certainly at the outset, it's not uncommon that direct evidence of the combination won't be available. And the courts are alive to that. And it may well be the case that that persists throughout. And you may never be able to directly show people agreeing that they're going to do something. But what you can do is you can draw inferences. And so have here an extract from the judgment of Lord Justice Nurse in Kuwait Oil Tanker Company SAK and Al-Baida number 3. This was an unreported case back in the 18th of May 2000, just before neutral citations came in. And what he said was that the court will scrutinise the acts relied upon in order to see what inferences can be drawn as to the existence or otherwise of the alleged conspiracy or combination. You don't need an express agreement, as I've said, but you also don't need the conspirators to all join at the same time, and nor do they need to have exactly the same aim. It's always a question in respect of a given defendant, question of fact, how far that defendant was A, aware of the plan, and then B, joined in the execution of it. And this is a recurring theme in the tort of conspiracy, that you might well think to yourself, well, that's a bit fuzzy. Question of fact, how far a defendant was aware of a plan and then joined in the execution of it. Well, how far is far enough to trigger liability? And that's what makes conspiracy perhaps one of the more difficult torts, certainly to advise in relation to, because so much of it, and we'll see this in relation to the unlawfulness of the means as well, we come on to talk about that, so much of it is about perception and how the judge understands the things that come out in the course of a trial. And that's very hard to predict. It's very hard to say how witnesses will come across. But it's also just hard to say, even if you can make an estimated guess as to how the witnesses might come across, there's always a difficulty in putting yourself in somebody else's shoes, the judge's shoes, and say, well, this is how I think a judge will interpret that evidence. This is the view I think they will come to, because obviously we are not non-partisan in litigation. We act on behalf of clients, and that imposes upon one a certain frame of reference. The judge doesn't have that same frame of reference, and so they may see things differently. And what we've got to try and do is step back when advising and try and say, how would somebody coming to this set of facts fresh interpret them? You've also got to bear in mind, who do you finger for your conspirators? Because how wide was a conspiracy? How wide can you throw the net? Now, one of the reasons why you might bring a conspiracy claim is because your primary wrongdoer, your principal defendant, may not have assets. So partly it may be a case of looking for somebody who's actually got something can be enforced against. And for that reason, it's not uncommon for the net to be thrown as wide as it can be, at least justifiably can be, at the outset. So I've seen this certainly acting for defendants, where I think, well, hold on, there's really not an awful lot here to go on. And some of the pleaded cases against you can look very, very thin. And I think that's sort of par for the course in this area. As long as obviously the pleading is properly arguable, people will throw the net quite wide. But that creates a risk. And the risk is obviously that as the case progresses, what the claimant is hoping for is that there will be enough evidence that comes out through disclosure from one or other parties, which will provide you with the information you need to buttress your case against those more fringe players. But it might not be there. And so in that sort of situation, it's not uncommon in my experience to see the net thrown wide, but ultimately it then must contract as the matter proceeds towards trial and people take a more realistic view about who they are going to be able to succeed against. It'll also be the case that more fringe players may come forward and look to do settlements, look to cut deals which enable them to get out at a more reasonable price. All of these things that mean that it's not uncommon in the context of conspiracy litigation that one might start off with a large number of defendants, but ultimately, when it gets to trial, quite a few may have dropped away. Now, once you have your combination, the next thing you've got to look at is the intention and the means. And I put these two things together, and here we have a beautifully AI-generated image of Caesar being stabbed on the Ides of March. I've been inspired by some of my colleagues' LinkedIn postings. I thought, well, I'll try and get some good images. I did also ask AI if it could write the talk for me, but it gave me nothing useful back. So I'm afraid what you get is all my own work, complete with all my own prejudices and mistakes, if there be any. The one thing that most lawyers know is that the tort of conspiracy can be committed through both lawful and unlawful means. So people are generally, in my experience, quite well aware of the idea of lawful means conspiracy and unlawful means conspiracy. It is, I think, an odd facet of this tort that persons acting in combination may be liable for loss caused as a result of their actions, where those actions were not themselves unlawful. But that applies in the criminal sphere as well. When one's talking about the crime of conspiracy, you can have, well, at least it did when I was doing things a long time ago. It was for a long time the case that you could have a conspiracy to defraud before the Fraud Act came in and introduced a specific offence for that. So, where the means are lawful, the requisite intention is one of a sole or predominant intention of injuring the claimant. Where the means are unlawful, the requisite intention is only one of injuring the claimant. It does not have to be the predominant intention. And that means that dividing up your case between lawful and unlawful means has a serious consequence as to what you need to prove in terms of the intention held by the defendant. Now, when you're talking about unlawful means, in Lonhro plc and Fayed, 1992 case, it was held that the desire to profit oneself can be, is just often the other side of the coin of intending to injure another, certainly in a sort of zero-sum commercial scenario. And so liability cannot be avoided by praying in aid an intention only to profit yourself if the means was unlawful. So you can't say, oh, well, I didn't desire to hurt them by doing this. What I was trying to do was generate a profit for myself. If those two things are the same side of the coin, opposite sides of the same coin, rather, then if you're engaging in an unlawful means conspiracy, that will be enough. There is a question mark as to the current state of the law in this area, because in JSC BTA Bank and Ablyazov, number 14, which is probably some sort of record for the number of cases, and Factor Tame, for those of you who remember that, got up to, I've at least seen up to number 7 in Factor Tame, but number 14 was doing quite well in terms of number of cases and decisions that were in this long, ongoing litigation. But in that case, the Supreme Court suggested that constructive intent may be adequate. Now, what happened there was just a single judgment given by Lord Sumption and Lord Lloyd-Jones, with the rest of the court unanimously agreeing. And what they were interested in that case were two specific questions. One was whether contempt of court could be the unlawful means in a claim for conspiracy. And the other was a question to do with jurisdiction relating to the Lugano Convention. So they weren't directly thinking about it. It wasn't a specific, and it wasn't a direct issue in the case what the requisite level of intention was, how you demonstrated it. But there is a suggestion in their judgment that constructive intent might be enough. However, this has been questioned subsequently. So Clark and Lindsell, in their most recent edition at chapter 23, paragraph 110, say they don't think that was what the court was meaning to do. It wasn't intending to row back from the need to prove an actual, objectively determined intention. What they weren't trying to do that. It was, nobody says it in these terms, but effectively that it was a careless comment. And that actual intention is still required, constructive intention is inadequate. So what then makes the means unlawful? Well, The case law tells us that the unlawful means can include the commission of crimes and torts. Where the crime is also a tort, there's little doubt that it will be unlawful means. Where the situation gets more interesting, though, is what of the situation where the crime itself is not an actionable tort. So, in Blighers of, they were trying to look at contempt of court, so it was somebody conspiring to defeat court orders effectively. Back in 2008, this question was looked at in Customs and Excise Commissioners and Total Network SL, and the House of Lords there confirmed that it was possible for the means to be unlawful, notwithstanding that it may not be actionable itself, provided it was the means by which harm was intentionally inflicted. Now, that might seem at first sight to be fairly straightforward principle, because, well, yes, you might think, as long as the thing that they're doing is unlawful in the sense of it being a crime, an infraction against the law, then it must surely be unlawful means. But the issue that you run into is that quite a lot of life is now regulated. There are lots of regulatory offences. There are lots of things that can be done that don't strike you when you then think of them as prima facie cases of unlawful means conspiracy. And the House of Lords recognised this in total. They accepted that some unlawful acts would not be actionable. And the example that was given by Lord Mance, paragraph 119, and he was citing an earlier observation made by Lord Walker in OBG and Allen, which had been decided a few months previously, was of the pizza delivery business that seeks to obtain more custom to the detriment of its competitors by instructing its drivers to breach the speed limits. And this, he said, would not be an unlawful means conspiracy. In Blighers of, the Supreme Court looked at this all again and confirmed the general principle that you could have unlawful means conspiracy where the unlawful act was not itself actionable, and so it extended to the contempt of court. But I'm not sure that the Supreme Court necessarily gave us a test there or an analysis that is particularly useful to practitioners trying to advise, because what the Supreme Court said was, well, there is a real test, and the real test was whether there is a just cause or excuse for combining to use unlawful means. And it was said that depends, one, on the nature of the unlawfulness, and two, its relationship with the resultant damage of the claimants. Now, to my mind, it is unclear how this then explains the pizza delivery firm. How do you bring that analysis back and say, well, if pizza delivery firm, along with its drivers, get together and agree that what they're going to do is go faster than the speed limit so that their deliveries are faster, thereby making them more successful, and in a sort of zero-sum scenario where their increase in deliveries causes harm to a competitor's business, which may, in the real world, perhaps not be the case, but in the hypothetical, at least let's expose it. How do we say, well, the nature of the unlawfulness there and its relationship with the resultant damage is not such as one as to pose liability? Obviously, you can say it, but there's no principled analysis, in my view, that actually enables you to explain why that's the case. Why is some unlawfulness problematic, whilst other unlawfulness isn't, if there is the requisite intention and there's the requisite causation? One of the other things that is a little bit unclear in the law of conspiracy, although the existence of it is perhaps clearer than the case law I previously suggested, is whether there is a defence of justification. So the High Court thought not in Palmer, Birch and Lloyd, and that's a 2018 case. But in an earlier Court of Appeal case, it called Merits Investments and ACP Limited, the Court of Appeal thought there was a defence of justification. Clark and Lindsell discusses this and ultimately suggests that there is a defence of justification where the unlawful means was breach of contract, because that means that there's a defence to the same extent as there's such a defence to a claim of procuring a breach of contract. So there's a defence of justification to a claim against you for procuring a breach of contract. And Clark and Innes will say, well, it would make sense, therefore, that if you're conspiring, which is not a million miles away from procuring, they are different torts, but often people will plead them in the alternatives, that it would make sense that you have a justification defence to conspiracy as well. But I'm not sure that that is obviously correct, given that procuring a breach of contract is actionable without any desire to injure the claim, and so is manifestly different to a claim for conspiracy, where the intention to injure is crucial to the action. It seems to me that it's very difficult, once you can establish that there was an intention to cause harm to a claimant. And in the context of lawful means conspiracy, we're talking about a predominant intention. And in the context of unlawful conspiracy, we're talking about an intention to harm coupled with an unlawful action. How do you then justify that? How can that be justified? I don't think it helps us, for example, explain the pizza delivery decision, because I don't think we can say that the pizza delivery firm was justified in its decision to conspire with, enter into a combination with its drivers to break the speed limits. So it doesn't solve that problem. And so I'm not entirely sure, whilst it's one of these things that one can say, oh, well, in theory, yes, it makes sense for these torts to marry up. In practice, when you then get to it, what would the justification be? What is one's justification for setting out with others on a course of conduct which is intended to injure a third party? Perhaps it's one of those situations where the answer is that it's not impossible. Maybe there'll be a situation where justification can be pleaded and made out, but that in most of the cases that's simply not going to be the case. And so it is worth retaining space for it conceptually within the tort, whilst at the same time recognising that it's not in practice going to be of huge utility or relevance in the vast majority of cases where the tort of conspiracy is in issue. Now, I think one of the interesting things about the tort of conspiracy is the extent to which it can be used to pierce the corporate veil. And I think this is an important practical consideration, because it can be the case, obviously, that what you're looking at are unlawful acts by a company, but that company itself has no assets. And what you want to do is try and get at the people their personal assets that sits behind the company. Can you conspire with a company? Well, firstly, yes, in principle you can, because a company is a legal personality and so it can be party to a conspiracy. But obviously, that legal personality is distinct from its directors or shareholders. And the mere fact that a company does something unlawful doesn't mean that you can automatically collar the directors or the shareholders for liability. But you can in some circumstances. Now, the starting point is to say that in general, a director or a shareholder will avoid liability if he does no more than carry out his constitutional role in the governance of the company. So, if a director is acting properly through board minutes and board meetings, authorised decisions, these sorts of things, then the starting point will be that it's going to be difficult for that director to fix that director or shareholder with liability. However, if such a person should fail to act in a manner that can be demonstrated to be constitutionally proper, they will be at risk of liability. Now, as a matter of criminal law, there's no ability for a one-man company to conspire with its sole director shareholder. However, in some respects, this may not apply in civil claims for conspiracy. So this is questionable. It's up in the air. There is some authority pointing in the direction of allowing that sort of conspiracy to be found as a matter of civil law. And in Società Esplosivi Industriali and Ordnance Technologies, Mr. Justice Lindsay makes an observation where he says, well, it would be undesirable to be in a situation in which the greater the control you have, and obviously a one-man company, a sole director, shareholder company, the individual has the greatest control. The more control you have over the company, the harder it would be to impose personal liability on that person. So they might set out to cause harm through the medium of their company. And to say, well, you can't pin them with liability for conspiracy because it's a one-man company and they were therefore acting properly, they had authority to do all these things in accordance with the constitutional niceties of corporate governance, puts you in a somewhat strange position where the greater the control you have over the company, the harder it then is to establish liability. Whereas by contrast, if you have a much larger company with disparate shareholders, directors, actually it then becomes easier because you can say, well, the directors here are conspiring with the company. One can certainly see the logic in that. But it is still, I think, open to say, how do you show that there was a combination between the company and its sole director? And how do you prove the intention? So whilst it might seem an obvious point, and it's certainly worth looking at in lots of cases, can you show a conspiracy between the director and his company in order to impose liability upon the director who's got some personal assets instead of just focusing on the company that's got nothing? In a lot of cases, I think you're still going to have difficulties. And I think probably where the tort of conspiracy is of most use in respect of piercing the veil sort of scenarios is really cases with shadow directors or de facto directors, where they won't be able to rely upon that constitutional protection of saying, well, I've just acted in accordance with the Constitution, because their control sits outside the Constitution anyway. It sits outside the Articles of Association. In that scenario, where you've got somebody behind the scenes, quite often it might be, for example, a shareholder who is not themselves anymore a director, founding shareholder, that sort of thing, then there is perhaps greater scope for using the tort of conspiracy to throw the net wide enough to bring that person in. And of course, that may well be useful because in more sophisticated corporate holdings, it may be difficult, especially if you are talking about transnational corporate holdings where perhaps you might have situations where ultimate beneficial ownership is somewhat obscure. If you can bring third parties in who you suspect of being ultimately the controlling party, and you can demonstrate that they were the ones working with the company and the company's directors to put in place whatever your particular harmful scheme may be, then that's obviously going to give you greater leverage, greater prospects of recovery. And so therefore something that's always worth thinking. And that's the way, just by way of concluding thoughts, the way I always think of conspiracy here. It can be tempting with all the economic torts to start to see them everywhere. And sometimes they create more heat than light. And in fact, you can run into problems with them because ultimately you're not going to be able to prove requisite intentions. You're not going to be able to demonstrate the things that you need to demonstrate. And in a case where you're making quite a strong allegation against a defendant, there are going to be cost risks in terms of the size of the costs that people can justifiably run up against you, the likely adverse costs orders if you fail. And so you've got to be conscious of all of that. But they are useful tools to have in your armoury, and they're worth considering. And so one of the major situations in which I think they're worth considering is where you're talking about, this is what the case law demonstrates, shadow directors, particularly useful situation. So with that in mind, I hope that whistle stop tour has given you all something to think about. We are at 10:33, so talk was designed to be half an hour, so we're more or less on the mark. I do have time if anybody wants to ask any quick questions, but obviously if you prefer, you can just email. It can sometimes be a bit tricky with the chat function, but if you prefer, you can email me any queries you have afterwards. And I am told that this will be recorded and you will get sent a link to it. And should you not, I think it goes up on YouTube and on the Chamber's website. So you can share it with all your friends and family. If you're stuck come Christmas for a really good present for somebody, what says I care more than an e-Christmas card with a link embedded to a talk about the tort of conspiracy? Probably nothing. So thank you all very much for attending today. Hope you have a good day, and do be sure to keep an eye out for the forthcoming talks from the King's Young Professional Seminars. There are more to come over the course of the year, and if there are things, we ask for feedback, and I know it can be a bit of a pain to provide feedback, but if you could take a moment to provide some, it's always really useful because it helps us. There's no such thing as a bad suggestion. Even the bad suggestions for future talks help us see what sort of things people are interested in and can help us tailor our future programmes going forward to make sure that we're addressing the things you all want to know about. So thank you very much and have a good day.